Okay, and I believe we are live on YouTube as well. It's 5 p.m., so let's get started. So, welcome everyone to Family Law Now After Hours. Today's topic is divorce timeline in Ontario. How long does it really take? Every divorce unfolds differently, but nearly all clients ask the same question. How long will this take? From legal requirements to court delays, many factors influence the length of a divorce, and understanding these timelines help you set realistic expectations and plan your next steps. Please use the Q&A feature to submit your general comments and questions about this topic. For specific questions about the details of your family law matter, please contact our team directly. The purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. Stay tuned until the end as we will share how you can schedule a free initial consultation with one of our lawyers. Now, to introduce our panelists this evening. Sonia has over 10 years of combined experience in family law, working as a law clerk and now as a lawyer. Her experience ranges from in-depth case research, preparing legal court documents, examinations for discovery, mediations, and court attendances. She applies her already obtained legal knowledge to better focus her attention on helping clients with their legal matters. Bill is a managing associate at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also has the privilege of winning a major family law victory in the Ontario Court of Appeal in 2014, McDonnell v. Huxtable, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. When he's not practicing law, he loves spending time playing music with his band Soul Custody. Jacob is a Toronto-based family lawyer who has practiced exclusively in family law since being called to the bar in Ontario in 2014. He has represented clients across a wide range of family law matters, including negotiating separation agreements and marriage contracts, and advocating for clients in court at conferences, motions, and trials. Jacob also assists clients through alternative dispute resolution processes such as mediation and arbitration. Outside of his practice, Jacob spends most of his time with his 2 young children. I will be hosting this event tonight, and I'm also one of the panelists. My name is Anna. I am a compassionate and strategic family lawyer who takes a client-centered approach in every matter. I help clients feel supported and empowered while navigating the emotional realities of family law. With strong communication skills and a collaborative mindset, I develop practical, tailored solutions that reflect my clients' goals. I've been recognized for offering clear, creative guidance in moments of uncertainty, enabling clients to feel confident and make informed decisions. I hold a Master of Laws from the University of Law in London and a Bachelor of Laws from the University of Sussex, grounding my practice in both advocacy and empathy. So, with that, let's begin. I think it's best to kind of start with just a general overview of kind of what some of the key stages in a divorce are. So, when people ask how long a divorce takes in Ontario, the first thing I usually explain is that divorce is not a single step. It's a sequence of stages, and each stage has its own timeline and its own pressures within that timeline. Some stages move quickly, and others slow everything down. But the overall timeline is shaped less by the word divorce itself and more about what needs to actually happen before that divorce can be finalized. The process usually begins with separation, but from a legal perspective, what's more relevant are the stages of filing, service, disclosure, negotiation, and finalization. So once a party decides to move forward formally, the first step is filing. And that might be an application for divorce alone, but more likely, an application will also address parenting, support, property issues. Filing itself can be quickly, but what matters is what's being claimed and how much needs to be resolved. So you're not in a position to be filing for divorce unless all these other issues are resolved first. So If you and your ex have come up with a separation agreement already outside of court, then you're in a position to file for divorce. If none of the issues have yet to be resolved, there's no separation agreement, you're not filing for divorce just yet. After filing comes service. Documents must be properly served on the other party, and proof of service must be completed. This can sound simple, but it can cause delays if the other party avoids service, if they live out of the province or out of the country, or if there's disputes whether service is valid. So nothing moves forward until service is properly completed. Once the documents are served, the process then shifts into what is the longest and possibly the most underestimated stage, which is financial disclosure. Disclosure is foundational and it requires, it could require negotiation privately through mediation or through litigation. Income, assets, debts, corporate interests, pensions, and expenses all need to be identified and supported by documentation. If disclosure is slow, incomplete, or disputed, the entire process can slow down with it. Courts are not going to finalize matters without proper disclosure, and a lawyer can't responsibly negotiate without it either. So, after disclosure begins, most files enter this phase of negotiation. This can happen informally between lawyers, through mediation, within a collaborative process, or alongside the court steps. And negotiation is rarely linear. So offers are exchanged, positions shift, new information comes in, and your priorities can evolve as well. So parenting issues may resolve before financial ones or vice versa. This doesn't happen necessarily one before the other. Each case is different. I think many people are surprised to learn that a significant amount of time in a divorce is spent waiting between these steps. You're waiting for documents, you're waiting for responses, you're waiting for instructions, or waiting for financial clarity. And only once the substantive issues are resolved or sufficiently narrowed does the process then move towards finalization. This might mean signing a separation agreement, minutes of settlement, or resolving outstanding issues through a court order. But the divorce itself is often the final administrative step. Once the legal requirements are met, including the 1 year separation period, the divorce can be granted without complication. So, when we talk about divorce timelines, what we're really talking about is how long does it take to get through each one of these stages? And when does the process slow down? So, keeping this like very general overview in mind, Bill, are there certain things that our viewers should be aware of? Factors that can speed up or slow down the divorce process?
Thanks, Anna. Yes, there are. And first of all, just to clarify, I think everyone knows this already, but if you're not married, um, you're never going to get a divorce. But you still have to go through all the other stuff, finance, parenting. So it takes pretty much just as long, you know. The divorce is really just a rubber stamp at the end for married people. Um, and it takes, unfortunately, it takes longer than you want it to take. That's a rule of thumb. I just, a lot of clients will say to me, look, I want to get this done so I can move over and turn the page, get on with my life. And I say, well, great idea. I support that, but um, it's very it's not going to be over, quote unquote, once you sign on the dotted line, especially if you have young kids. You'll be probably co-parenting for another 10, 15 years with your ex, and you want to do it amicably. So it's a fallacy to think that, once you sign a document, you're going to suddenly feel a whole lot better. I mean, you might feel a little better, but not it's not really. the be all and end all that people think it is. And especially a lot of times you have clients who will say, well, I don't really care how much money I get. I'll waive um, some financial stuff. Because I just want to get it done. What I say is, well, you say that now, um, but in a year's time, you'll be kicking yourself. So don't do anything hasty. Um, you can waive a financial entitlement, but you have to find out first what that entitlement is. Then you can talk about, do I really want to waive this or not? And that's why if I have a client who says, I don't care if I don't know how much I'm giving away, I'm just desperate to get this done, I say, no, you really can't do that. That's not good. It's not going to help you. And as you mentioned, the disclosure part, it takes time and there's no shortcut. Um, Sometimes you have to get things appraised and evaluated. Real estate, even more difficult is valuing if someone has a business. Sometimes that business actually has a value. Not always, but you have to get a professional to calculate that, and it takes time. If you go to court, which sometimes that's the best answer. I mean, that takes longer than everyone thinks. I mean, it's months, years. That's the way it is. I mean, if the first court appearance for family law, they call it a case conference, and it's not uncommon to have that like 6 months after the initial filing because the courts are overloaded. So, what I always say is try to be patient and try to not give in to the desire to be vindicated and have someone say, you know what, none of this is your fault. It's all your ex. People want that, and I don't blame them. But the courts aren't designed for that, and they rarely do that. They usually go somewhere in the middle, and it's difficult. So um, I think that's kind of an overview of the situation. And again, you have to have, whether you're married or not, patience. It takes time, unfortunately. But if you do something hasty, you'll regret it.
Thank you, Bill. Yeah, I think that's, a big part of our job as lawyers is managing those expectations. And I know we're going to talk about that more later on. But having that conversation with your client and ensuring that they understand there's certain things that are in our control and there's certain things that aren't. And sometimes those timelines, especially when it's court proceedings, are outside of our control. Once people understand these stages, usually the next question is, how do we get this resolved as quickly as possible? And the answer almost always comes down to a process choice, right? Like, let's break this down and say, okay, are we going to move forward with a collaborative practice? Are we going to move forward with court proceedings or mediation? And sometimes there's an obvious, appropriate answer. But other times there's room for selection, right? Court, collaborative process, mediation, they're not just different in their tone, but they're structurally different as well. And those structural differences can directly affect the timelines. As you said, Bill, a court-based process is governed by formal rules and external scheduling. So steps must occur in a particular order. Documents are to be exchanged between the prescribed formats, and appearances happen based on court availability rather than the party's readiness. So even when everyone's acting reasonably, court files are often more slow because they are competing for limited judicial time. There's adjournments, there's procedural disputes, and there's mandatory waiting periods built into that system as well. Where a collaborative and a mediation process operate very differently. They remove court bottlenecks by keeping decision making with the parties rather than within the system. So meetings are scheduled based on availability, not the court's calendar. Disclosure is exchanged voluntarily rather than compelled through procedural steps. And this focuses on resolving the issues efficiently rather than positioning ourselves for litigation. Now, that being said, alternative dispute resolutions are not automatically fast by any means. It moves quickly when the parties are prepared. So, if disclosure is incomplete, instructions are unclear, or emotions are still just very raw, mediation and collaborative files can still stall just as easily as a court file would. I think the key difference is that the delays in mediation or collaborative practice are usually internal. It's readiness, it's information or decision making, whereas delays in court are often external and outside of everyone's control. Another important distinction is that court processes tend to address issues sequentially, where mediation or collaborative process can address the issues in parallel. So, parenting, support, property can be discussed together in a way that allows for trade-offs or creative solutions, which often shorten the overall timeline. Ultimately, alternative dispute resolutions tend to be faster because it avoids the procedural congestion, but it still depends on engagement and transparency and just a willingness to negotiate on both parties. So now, one thing as family law lawyers that we are no stranger to is conflict. You can think of a client matter going one way, you can have that initial call, think you have a good grasp on the situation, and then within one day, one email, or one incident, it's going in a completely other direction. So, with that in mind, Jacob, can you explain how conflict can impact the duration of a divorce?
So the very short answer is it can make it way, 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 way longer. So, I mean, if you compare the two extremes, on the one end, you have everyone's getting along great. You reach this negotiated agreement in a reasonable amount of time. Then all that's left is getting your actual divorce order itself from the court. You've got your agreement done. The other end of the extreme is you have a contested court matter that goes from the beginning all the way to the very end, which means you have to draft your pleadings, you have to go through your financial disclosure. You're going to have, at a bare minimum, before you can have a trial, a case conference, a settlement conference, usually some sort of trial readiness, trial management conference. In the midst of that, you also might have one or two motions to decide interim issues. You might have questioning where you're getting lawyers asking each party questions on the record under oath in front of a court reporter, just outside of court. And then after you go through all that, then you'll have an actual trial. And the length of time on that can be 2 years easily because you're completely limited once you're in the court system by the availability of court time, which unfortunately is in certain courts very, very difficult to get. You can be waiting months between court appearances. And if you have to go through that many court appearances, plus you're going to have a trial on multiple issues, which might take a week or two of court time, and booking that, courts only do specific times a year. You could be easily in for 2 years, a ton of court appearances, a ton of documents until your court matter is done. That's not to say listen to that, never go to court because sometimes your hands are tied and there is nothing else you can do, because you can also have within a negotiation process an impact of conflict where someone says, sure, yes, let's negotiate. You start going through that process and you see they're not actually buying into the negotiation process. They're spinning the wheels, they're dragging things out because unfortunately, if you're the person who's going to get paid money, you'll often find the person who has to pay you money has a lot of reasons all of a sudden to delay. And it can simply be they don't want to pay you and they're hoping and go away if they make your life difficult. So you can see that impact of conflict in court. You can see it in a negotiated process. They're trying to exhaust your time. They're trying to exhaust your resources. They're essentially trying to exhaust your will to fight because they're thinking, hey, if I have to pay you a lot of money and I can use the process to make your life miserable, maybe you'll give up. Maybe you'll go away. So you can see that in a negotiated process or in a court process. And unfortunately, in a negotiated process, if someone is really intent on just spinning the wheels, making your life difficult, there's really nothing you can do other than go in the court process, as cumbersome and unwieldy as it is. The good news with all of this, though, is, it works both ways. If somebody else is making you take them through the court process, they also have to put all the time and the work in. They have to show up to the court appearances. They have to get the documents done. So it's not going to be a lot of fun for them either. And the other aspect of that with both these things with conflict is sometimes you'll see there's conflict initially. Someone decides, they're going to show up to court, they're going to put on a whole song and dance. They go to the first case conference, and the judge has some choice words for them. And they quickly see, okay, you know what? Maybe being a difficult person is not as fun as I thought it would be. I got to shape up. Let's go and get this done. So, I mean, the whole extreme of going all the way to a trial, it does happen. That's kind of your worst case for conflict lengthening out your matter. But usually you'll see sort of the degrees of that where someone's difficult at first. You can't negotiate. You take them to court. You have your first court appearance, maybe two court appearances. And then all of a sudden you see, okay, now they're finally willing to kind of settle down and get this done. So, I mean, conflict is real. It will drag your matter out. But, as Bill was alluding to, don't take that and say, okay, I'm not going to try it. I'm just going to give up, because that's also not a good answer. You just kind of have to go in knowing, hey, here's what could happen. Here's how bad it can be if this is a high conflict matter. Prepare yourself for that sort of emotionally, mentally, financially. Keep that in mind as you're deciding, how does the core process look compared to the deal that's on the table? But, never forget just how long and how exhausting a drawn out, conflicted family law matter can be.
Yeah, thank you for that, Jacob. I think, one thing I was thinking of while you were speaking is that our clients, the viewers, this is a conversation to be having with your lawyer to give them all the information so they can explain to you the process of, the conflict is high, but what is the solution you're looking for here? Where can we get to that outcome? Because I think a lot of people think that court procedures are the only way forward, and that's kind of what people think of when they think of divorce, right? We have to go to court, but a lot of the time there are other alternatives available. And sometimes, based on what the conflict or what the specific matter is, it may not be the appropriate avenue. But it seems like with some of the examples you said, there's certain things that are in our client's control or the party's control. And there's other setbacks that are completely procedural. Sonia, can you please explain some of the procedural requirements and waiting periods that are required?
Yeah, absolutely. So, to piggyback off of what Jacob was saying, two ways that you can do this: negotiations of a domestic contract, i.e., separation agreement, or litigation, the longer process, and obviously depending on how busy the court is. Okay. Now, the reason why you're negotiating outside of court or in court and trying to come up with a solution, or sorry, a resolution, is because you're trying to figure out all the other issues: parenting, child support, spousal support, equalization of net family property, things of that nature. And once those are, I guess, concrete, you've come to an agreement either via separation agreement or received a court order, all the legal requirements in that aspect are met. And from that point, you're able to proceed with a divorce. So I'm going to just, I guess, generalize wait periods and after we've established an agreement or a court order, or so received a court order. Okay, so generally speaking, procedurally, there are three wait periods. And I'm going to use the example of being separated for at least 1 year. Okay, so separation for 1 year, 365 days. That's one wait time. Second wait time, 30 days after, 30 days after you serve the other party with a divorce application. There's a wait period there. And the third wait period, generally speaking, is the 31-day wait period to submit to the court a certificate of divorce. Okay, generally speaking, okay? Procedural requirements. There are 3 ways you can proceed via divorce. Once, as we've said, negotiations of a separation agreement or court order is received. There's either a simple divorce, uncontested divorce, and a joint divorce. Okay? Joint divorce is where both parties have agreed and have applied for divorce jointly together, and they sign the same document and they submit it to the court. Simple divorce is when you're asking for divorce only. There's no claims for property or any kind of support. And an uncontested divorce is you're filing, one party is filing, and there's no answer being replied to. I will get into that. Okay. So here are the key steps. And I'm reading off a paper so I don't forget because I know that there's an order. All right. So we have first step, you prepare your application. So your Form 8A application for divorce. And when doing so, you're going to need to have your marriage certificate because you won't be able to file any of your documents with the court unless you also submit to the court your marriage certificate. Next step, you are serving your application for divorce on the opposing party, unless it's a joint divorce application. In that case, there's no service required. A note for all parties listening or all people listening, service cannot be served directly from one party to another. You will be required to hire either a process server or some kind of professional or a friend. Someone else has to do the service.
Can I just interrupt really quickly?
Yeah.
Back in the day, you used to be able to serve yourself, like actually serve your spouse directly.
Well,
I know a guy who got served papers while he was in the shower, and it's not good, and that's why they don't do it anymore. Sorry, Sonia, I just had to throw that in.
that's okay. You can serve them in a very uncompromised position. That's definitely what people would do, I assume. So service. Once that service is done, whoever served has to prepare and swear an affidavit of service. Okay. Next step, court filing. You will then need to file to the court your application for divorce, along with your marriage certificate and the affidavit of service. Again, if it's not a joint divorce, affidavit of service. You will be filing this with the Superior Court of Justice or the Family Court Branch. You will also then need to pay the court filing fees for this divorce. So the total, I believe, is about $669, which are, I guess, there's 2 installments. One is $124, and the second installment is $445. Okay. Then we have a 30-day wait period. From the date that you serve the opposing party, they have 30 days to dispute the divorce should they wish. Okay. If they do wish to dispute the divorce, they will have to prepare and serve and file what is called an answer. If they do not do this within the 30-day time period, then the initiating party may proceed with as an uncontested divorce. Okay, that means they can file an affidavit for divorce, which is a Form 36, to the court. And this is where you would, I guess, check off or explain that, for instance, you've been separated for 1 year, and this is why you will wish to proceed. Your affidavit for divorce is also filed with a Form 25 draft divorce order, 25A, draft divorce order, okay? Then you wait, again, for the judge to endorse the divorce order. Once the judge endorses this divorce order, you will receive the divorce order. Then 31 days from that divorce order date, you may file with the court a blank certificate for divorce or divorce certificate and wait for the court to sign that and send it back to you. Once you receive that certificate of divorce signed by the court, you are officially divorced and you may proceed with, for instance, remarrying. Okay. That is the brutal, long process on how to proceed once you have finalized all your other issues. So,
Thank you for
I
that,
think
Sonia.
that's
You explained it
it.
very clearly.
I had to.
No, I'll say like, so that this is kind of what we were discussing before, right? This is the process after all the other issues have been dealt with. The end goal is to be able to finalize and the divorce. But before that, we have certain issues we have to deal with, right? And a lot of the time, the issues can be related to what are we going to do with the kids? What's parenting time like? Who's going to have decision-making responsibility? So, Bill, can you talk about, or just talk a bit further, because I know we've touched on it briefly. When are child-related issues there, and what does that timeline look like?
Okay, Anna. Now, there's two aspects to parenting or child issues. One is decision making about the child. They used to call it custody, and they renamed it decision making responsibility. That's what it always was. So it's much better now. You don't have to explain to people, well, it's custody, it means decisions. Now it's actually called that. Um, Basically, it's about significant decisions, not day-to-day stuff, significant decisions about healthcare for the kids, education, religion, and extracurricular activities. Um, Now, many a time I've been in court and um, the parties have been separated, less than a year, let's say, um, and they're not going to get a divorce yet, but they're already fighting about parenting, which you can do. And the judge has said to me, it's too early to decide on decision making. Not enough time's gone by. We don't have enough information about what's best for the kids. And that's all the court cares about. They don't care about the parents. It's all about the kids. So it takes time to get a decision about decision making. And my philosophy, which I think is the majority philosophy, is unless there's abuse or neglect, uh, the best way to go for the kids, for the happiness of the kids, is joint decision making. Because that avoids what they call the winner-loser parent syndrome. Mommy, why is Daddy not allowed to be in the loop about significant decisions about my healthcare and education? What's wrong with him? That's what the kid's gonna think. So the best way to avoid that again is to do joint decision making. It's you both parents have to agree on it, but it's only significant decisions about health and education and religion. There aren't that many of those really. And usually for healthcare, you listen to the doctor. If you're not in private school, sure, there's decisions to be made, but not that many. So my advice is always try to go for joint. I know it's hard. I know you want your ex to be publicly executed, which we cannot do, but for the sake of the children, try to go for joint. And unless there's abuse or neglect, and of course, every client says, yeah, there's lots of abuse and neglect on the other side. Well, I'm talking about bad abuse and like there you'd be surprised. You've got to be charitable in your viewpoint there, because again, you don't want the winner loser parent syndrome. It really hurts kids. The other issue is parenting time, and that you know how much time does the kid spend with each parent? And again, my recommendation, if you can swing it, is try to go for 50-50, or if not that, what they call shared, which is 60-40. Um, no one, the other person doesn't go below 40%. If you can do that, once again, you avoid the winner loser parent syndrome. So that's my philosophy. I think a lot of the courts kind of agree with that too. It's not easy to do. It really isn't, because in separation, there's a lot of hard feelings. And what I always say to my clients, and they hate it, is love is the answer. And when I say that, I mean try to steer away from hate. That's the beginning of what you need to try to do. And the more you can do that, the better off your kids are going to be.
Yeah.
Absolutely. And you know what, if they don't take your advice, Bill, maybe just remind them that it's adding to those delays. It's adding to prolonging the timeline. So
Well, that's right. Exactly. That's exactly right.
I know we already spoke about, those procedural requirements and the waiting periods, but Sonia, I'm going to come back to you. Is there anything about the document preparation, not just the service deadlines, but like preparing those documents, that we can speak on in terms of the waiting process or how long that can take, right? I know sometimes we have clients coming to us saying, I want to file this urgent motion today. Like, how long does it take to actually prepare these documents?
Okay, well, do you want to talk about the whole process from pleadings, or would you like to talk about, like, I was actually confused with this question. I'm not gonna lie. Like, I know all the deadlines, but I I'm gonna be honest. I don't know. I'll just say everything. Here we go. Okay, so if you want to start a court application, um, you prepare it, sign it, send it to the court to get issued, meaning you get a court file number, get it back from the court, hire a process server, serve the other party. From that point, they have 30 days to serve and file what is called an answer. Okay. From that 30, after they file that, serve and file their answer, the applicant has 10 days to, should they wish to serve and file a reply. The reply is not mandatory, but it is advised to be completed, served, and filed. From then, pleadings are closed. The next court materials needed in litigation process is a case conference brief. This is the standard practice, unless there's an urgent motion. We're not going to talk about that right now. We're just going to talk about case conference. So, case
Can I
conference
just
one.
jump in real quick, Sonia? Sorry.
Please.
I
Yep,
just can't
please.
resist interrupting you.
That's fine.
Um, everyone thinks their motion's urgent, and it
Yeah.
is. Like, it is to them. It really is. But to the court, it's probably not. Because what I say is they're dealing with stuff way worse than you, like child abduction, like it's really bad stuff. So that's another conversation you have to have with the client. Like, I know it is urgent, but we can't actually meet the test under the law. Anyway, sorry, Sonia.
Yeah, Bill, you and I have had
Well,
many
that's
conversations. Yeah. Like, I now know what is actually urgent in the eyes of the court, because that's what matters. Um, so leaving that aside, we're going to just talk about the first step, which is case conference. So the party that's requesting the case conference, you have a date now. The party that's requesting the case conference has to prepare what is called a case conference brief. This is served 6 days before this business days. Before the, actually, no, 6 days, sorry, my bad. 6 days before the actual case conference. And the responding party has to serve their case conference brief 4 days before the case conference. There's also something called a confirmation form, which is done 3 days before, confirming the date and how everyone will proceed. There you go. Then you have your next step, which is a settlement conference. Same thing, same deadlines, except it's a settlement conference. In between the case conference and settlement conference, should a party want to proceed with a motion on one, possibly two different main points, they may do so. They would then serve and file a notice of motion, well, depending on everything, but a notice of motion with supporting documents, i.e. Form 14A affidavit. I do believe this is served, well, depending on the court, I do believe. There's all these different circumstances. Some courts want it 30 days in advance. They want notice of motion. They want the whole 9 yards. So depending on the court, and again, your lawyer will advise you on deadlines for that. That as well will need a confirmation form, which is, I think it's called a 14C. That is confirmation of motion 3 days before. It must be served and filed. I'm sorry, not served, just has to be filed with the court. Are we going to continue? We're going to go to a trial scheduling conference and a potential trial. I don't know if we should, but if we have to go to trial scheduling conference, same rules apply for the briefs. I'm not going to, it's very rare to go to trial. And you know what? I'm not going to lie. I haven't been to trial, so I don't even know the deadlines. I don't know if Bill wants to take this one or Jacob.
It's a free for all.
Yeah. Okay.
Yeah, it depends on your trial, depends on your court. But I
Yeah.
mean, I think you have all these deadlines memorized much more than I do. But I think the long and the short of it is it's complicated even for us.
Yeah.
And, we are always checking and double checking deadlines because as Sonia's saying, rattling off the list. And I mean, and there's rarer things that have different deadlines in different courts. It's complicated even for us. So, I mean, if you hear this and you're overwhelmed, like lawyers will freely admit, it is not an easy system to understand if you're not immersed in it.
Yeah. Yeah.
Absolutely. And that alone is, one of the benefits of having the lawyer on your team, right? It's someone else to kind of help manage this calendar of deadlines that are now going to be approaching. Sonia, was there anything else you wanted to add? I don't want to interrupt you. We're good?
I can go on for days. Like, do you want to know exactly what you have to file in your pleadings? Like, we have depending on 13, we have a form 13-1. I'm not sure. An affidavit for decision making response. There's all kinds of stuff. So I would recommend speaking to a lawyer. They will assist you here at Russell Alexander Collaborative Family Lawyers. We are here and we can assist you. We will assist you, and we will do our very best to help you in this matter.
Absolutely. And maybe, how I'll transition into our next question here is that, a big part of our job as lawyers is managing these client expectations. We know the timelines, and if we don't, well, if I forget anything, I'm calling Sonia now because she's going to know for sure. But a big part of our job is managing these expectations. So clients know, what can we expect? What kind of delay are we looking at? And I would say, before I kind of dive into this topic more, if any lawyer or any legal professional is confirming or is telling you 100% this is the outcome we're going to get, that's a red flag. There's no promise on what an outcome's going to be. There's no promise on what kind of delay you're going to experience either, right? We can have, especially with our experience in certain court systems, say it's probably going to take this amount of time, or, what I've experienced lately is this is kind of the delay we're looking at, but nothing can be guaranteed. And delays are one of the most emotionally difficult aspects of separation and divorce because they create uncertainty, they create prolonged stress, and they often make people feel powerless in a situation that is already a huge transition. One of the most helpful things clients can do is separate delays into two categories, okay? What can we control and what is outside of our control? You generally cannot control how quickly the other party responds. And I'll say that to an extent, right? Because we can put pressure on the other side and keep doing check-ins, but or we can't control how emotionally ready they are to move forward or how long these external systems take. We can't control court backlogs, judicial availability, or the administrative processing times. But what we can control is how prepared we are. So we can control how promptly we provide this disclosure to an extent. Of course, like as Bill mentioned, sometimes there's business valuations that take longer, but as long as we ensure that we're organized and prepared, that's how we can move things along as quickly as possible. So how organized these documents are, how clearly we are given instructions, and whether you engage in the process consistently. So delays often compound when one small step is postponed, right? Financial disclosure is delayed, which then is delaying negotiations, which then delays any sort of settlement. And it's just ultimately delaying any sort of finalization in the process. So understanding that chain reaction helps manage frustrations. Another important expectation or an expectation shift is recognizing that progress is not always visible. A file can be moving forward even when it feels like nothing's happening. Documents can be under review, or positions are developing, right? Your lawyer can be having discussions with the other lawyers about strategy, or I should say the other lawyers in their firm, right? They're not going to call opposing counsel without you being aware of it. Or having those type of negotiations, but we're narrowing those issues behind the scenes. But it can be frustrating when you're not seeing that visible progress. So that's another main part about managing these expectations. It's also important to understand that speed is not always a positive indicator. And Bill, you touched on this earlier, right? Sometimes clients want to like rush things forward, but we really need to take a breath and a step and look at the picture clearly before we decide what our next action is. A faster outcome is not necessarily a better outcome, particularly when children or long-term financial security is involved. We want to make sure that we're being thoughtful with this decision making, and that takes time. So some of these delays are a sign that issues are being taken seriously rather than rushed. So managing these expectations does not mean accepting unnecessary delays, but it's about understanding the difference between available or sorry, avoidable delay and inherent delay. So it's focusing our energy where we can actually make a difference. And when clients understand the process and the timelines and their own role within that, that's when delays maybe become easier to tolerate or, maybe just a little bit more pleasant because now they make sense. So a slower process that leads to a sustainable outcome is often a lot more healthier than a rushed resolution that's just going to create future conflict. And it's ultimately not going to be a good fit for your family, right? So you know, if we're going to talk about what's in our control, what can move a case forward more efficiently, Jacob, I'm going to turn to you and ask, is there any strategies that people can use to move their case forward more efficiently?
So the first thing I'd say is don't procrastinate. And I mean, nobody loves dealing with the separation. Nobody loves dealing with financial disclosure, all the emails and stuff a lawyer is going to send you and need, thinking about getting a lawyer, thinking about what you're going to do next. But the sooner you get started on the process, the better. And that's also going to go through every stage of the process. I have clients who respond to me right away. I have clients who respond to me in a month, right? And obviously, we get it. It's not just the normal kind of people are busy. It's tough emotionally, right? You've been dealing with a lot of stuff. You're continuing to deal with it. It's hard to face it, but the more you are able to quickly address everything, the faster your matter is going to go. Because if you on your end are slowing things down, then your matter's not going to go quickly. And second step I'd say is be prepared. And that factors into a lot of things. One of the things is financial disclosure. Have you been doing your taxes? Do you have access to your taxes online? Do you have online banking? Do you have access to your bank statements, credit card statements? If you've got, assets, real estate in a foreign country, for instance, can take a lot longer to get those documents together. So think about how you're going to get that, where you're going to get that from. And it's also in terms of, what do you want out of the separation process? Start thinking about that. If you and your former spouse, partner are on good terms, having the conversations between the two of you about, how you want this to go, how you want things to be. If you are in a position to, communicate without lawyers, not always the case, but definitely sort of being prepared in all aspects, certainly helpful. Number three, I would say is really, if you start to get into a process where it seems like maybe the other person's delaying, things aren't proceeding at the pace you want them to, is starting to define, okay, here are my red lines, here are my boundaries, here's how long I'm going to give this person to do these steps, and say, you know what, this has been going on for a while. I'm waiting forever for financial disclosure. I'm willing to give it 1 more month, 2 more weeks, whatever it is for each stage, and really kind of thinking out, okay, I know the person, I know their situation, I know what's been going on. How long am I going to give this person? And really kind of thinking about that for each step. And then the follow up to that is, once you've set those, okay, here's my reasonable boundary. If this person continues to not adhere to those timelines at a certain step, you have to go, I need to start taking action to enforce what I have said. And sometimes you're just getting someone who, maybe they're not being a bad person. They're procrastinating. They're dragging their feet. This is kind of the same personality of, you've been living with in a relationship for years. This is who they are, it. But unfortunately, as much as you don't want to seem like the bad guy, you kind of know, like, there's no way this person's getting their stuff together unless I hold their feet to the fire a little bit. I got to start court proceedings. I've given, this much time for a negotiation process. I still don't even have a financial statement, right? So at a certain point, you have to go, all right, as much as I don't want to, I need to start thinking about how I can get an outside process in. Maybe it's an alternative dispute resolution, maybe it's court, but at a certain point of time, you sort of need to go, I've made my threats, I've given them my deadlines, they still haven't listened. And really, kind of for all the reasons we've talked about, it's not the smoothest process, but the only real process with teeth behind it that we have if someone's completely not doing anything, dragging their feet, is their core process. And, as slow as it is, it will start to impose deadlines with consequences on people who are kind of, not even giving you document one of their financial disclosure. So those are kind of the best strategies I can think of. And those remain ongoing, right? And a lot of times you'll see within a core process, adhering to what a judge has said in an endorsement, making sure you are meeting all your deadlines, all those sort of court forms and deadlines with documents Sonia was talking about. You want to make sure on your end that you're not missing or messing anything up throughout the process, because as soon as you do that, now you're the reason for the delay. You can't just blame the other person anymore. So really, those things continue through a process or a negotiation process as well. If you've done your financial disclosure on time and now it's time to review drafts of an agreement and you start dragging your feet on that, you're going to find yourself slowing down. And really, the problem with that stuff is things change. So if you come to a lawyer, say, I want an agreement, here's the situation, then you drag your feet for 6 months. Maybe now a lot of things have changed. Maybe now you have to update your financial statement. Someone's gotten a new job, kids are going to a new school, what have you. So the more you delay, the more changes there are, the slower you go. So you really want to not delay, get things done, because otherwise you just kind of end up this cycle where things keep changing, things keep having to be rewritten, nobody's finalizing anything, and you're going on forever. It's time, it's money, not what you want to get into. So those sort of things I've mentioned, those are ongoing. It's not just when you start the process, you really have to be strict with them throughout.
I
Thank you
would
for
like
that,
to add
Jacob.
I'd
Yeah,
like to add something, and it happens a lot, more often than people realize. Sometimes the other party that's just dragging their feet, not disclosing, not responding, the second you commence a court application, suddenly they're your best friend. The other party's your best friend, and now they want to negotiate. They give you everything you want just to take it out of court. And you know what? Sometimes it works, and the whole matter is resolved very, very quickly. So that's something to remember as well.
Yeah, so
yeah,
definitely don't be afraid to, take action if necessary. Because yeah, like Sonia said, sometimes you gotta hold their feet to the fire a little bit and then you'll find their participate. But yeah, once you have that sort of boundary of I've waited this long, I'm not gonna wait anymore, you've communicated that. Do not be afraid, like Sonia said. The teeth behind anything is taking them to court.
Yeah, I'd say just to add to that in reflection to what you've said, Jacob, and what you've said, Sonia, is that what's in our control or in the party's control is often what's guiding our strategy, right? So in terms of what our next move's going to be, it's about what delays have been brought forth either on our end or by the other party. So it's important to understand what's in our control and what's out of our control. So kind of just to summarize everything, because Bill, I know we've talked a lot about this or answered this question already within the other ones we've already discussed this evening. But to help our audience understand when timelines are out of your control, can you speak to that, please?
Yes, Anna. I did a trial once, like waiting for a decision from a judge. There's not much you can do. Um, what you don't want to do is contact the court and pester the judge because you don't want to get them angry. And I did a trial once, and it took a year to get the decision. That judge is no longer on the bench, but that's out of your control. However, like Sonia said and like Jacob said, court is actually a great way to speed things along, hold the other person's feet to the fire. And just because you're in court doesn't mean you have to stay there. And most people don't. I mean, only a tiny fraction of cases ever go to a trial. So court's a great option because it's going to move things along, and then you settle. And it just really greases the wheels of that. So court's what you can control. You can't, but don't be afraid of it because it will move things along, and then you settle, you get out of it.
I appreciate that, Bill. Thank you. I think that's, a good place for us to maybe end our conversation. So with that, I will say thank you to tuning in to After Hours. After this session, and before I continue, thank you very much to all the panelists for taking the time to speak to me tonight. I think we got a lot of great information across. So after this session, a brief survey will appear, allowing you to share your comments and suggestions for future topics you'd like us to explore. Your feedback is greatly appreciated. Book now and take advantage of this opportunity for a complimentary consultation with one of our lawyers. Please contact our intake team at intake@russellalexander.com and mention our After Hours series to schedule your appointment. Registration is now open for our next event, Separation Agreements in Ontario, Key Clauses to Protect Your Wealth. Please go to russellalexander.com/familylawnow. Thank you again to my panelists and for sharing your insights today. And thank you all for tuning in to Family Law Now After Hours.